Everyone, welcome to this launch talk. Thank you for attending. And I'd like to introduce you to Professor Howell Jackson, who's a professor of law at Harvard Law School. He's also a JD and an MBA from Harvard. Professor Jackson has served as a consultant to the United States Treasury Department, the United Nations Development Program, the World Bank, and the International Monetary Fund. He was also a clerk for Justice Thurgood Marshall on the Supreme Court, and he will now deliver his brilliant lecture on cost-benefit analysis.
Great.
So, ladies and gentlemen, Professor Howell Jackson.
Thank you very much, and thank you to Judge Bodart for arranging for me to be here, and also for taking the time to come and be a student, and a wonderful student at Harvard Law School this past year. And I'm very pleased to participate in this forum, and on behalf of the faculty members, I don't know how many Harvard faculty members you've met yet, but welcome to Cambridge and Harvard Law School. As Bruno mentioned, I'm going to be talking about a research project about cost-benefit analysis in the United States, which is a project that I've been working on for a couple of years, and I presented at a seminar that Bruno was in, as well as a few other students who are here. Mostly what I'm going to talk about is this research. But I thought I would say a little bit about some background information, which might be of interest to you since we're at a law school. And I wanted to explain a little bit how the research fits into the law school. You'll see that it fits in a lot of different ways. But one way is, as I'm working along this project, I have a seminar this year on cost-benefit analysis that Bruno and Lilian and Heinrich and others are in, and we spend the year basically working through the legal literature and legal requirements of cost-benefit analysis that I'm going to talk about a little bit, and a very extensive law review literature about cost-benefit analysis in the United States, and the role that the courts have or maybe don't have, this is disputed, in cost-benefit analysis, as well as the kind of economics of cost-benefit analysis. So, one of the things that we try to do at Harvard Law School is combine both legal studies but other disciplines like economics and political economy into our teaching, and we not only try to do that, but we try to make our students participate in the legal process by writing papers. And so in the spring semester, which we're just finishing this week, the students have to come back with their papers on this topic. And in fact, I have Bruno's paper right here, a draft of it. A little more work to be done, but it's a very good start, and I'll say a little bit about it in a second. One of the distinctive features, the students here will recognize this is a book that I've kind of been hitting them over the head with. It's not a law book. This cost-benefit analysis book, which is a text that we use, is designed for schools of government or schools of public policy. It's what economists and public policy analysts are taught about cost-benefit analysis, basically how to do cost-benefit analysis. And there are either no legal cases or hardly any legal cases in this book. What there are a lot of are charts and graphs. And this is kind of what the public policy analysts have in their head when they talk about cost-benefit analysis. That with various projects that get more and more elaborate, there will be costs associated with them that will go up as the projects get more elaborate, and they will generate benefits that are going to decrease over time as the projects get more elaborate. And what the public policy analysts are trying to do is make sure that they do projects where the benefits are greater than the costs. And they don't want to get way out here where the costs go way up and they're more than the benefits. And if they're really hitting on all cylinders, what they want to do is find the place where what's known as the net benefits are biggest. I mean, it's a good thing to do anywhere where the benefits are more than the costs. That's great. But you really would like to pick the one where you maximize net benefits if you're an economist. So I'm not going to sort of go into more detail about that. But there's this kind of conceptualization in the policy world about how cost benefit should be done. And I'll just represent to you, there are many more charts and graphs and equations and mathematical things in this book which kind of explain that. And one of the goals of the seminar is to have the students try to bridge the gap between the economics of cost-benefit analysis and what actually goes on in regulatory agencies and also in courts sometimes when the legal question is, has cost-benefit analysis been done correctly or incorrectly? And that's kind of an important question in the United States. So I'll say a little bit more about this as I go along, but the students, Bruno and Liliana and others, have written a bunch of papers for the course about specific examples of cost-benefit analysis, and also a set of papers about, I'm calling it overarching perspectives, but this paper of Bruno's is right, whoops, where'd he go? He disappeared. No. This is Bruno. Your paper has disappeared. Okay. Witchcraft. It's a very good paper about the role of the judiciary in. Did I do something? I don't know. I went out of the zone. About the role of the judiciary in doing cost-benefit analysis. And then there's another set of papers that are called about comparative topics. One of them is about cost-benefit analysis in Brazil, actually. Okay, thank you. That was quick.
You can talk about my paper again.
Yeah, okay, we're off of your paper now. Okay, CBA in Brazil. Lilian, is Lilian here? Miranda Machado has done a very interesting paper about infrastructure projects, developments in the Amazon and other places, where, for the most part, as I read it, there's not much cost-benefit analysis done. Another paper is about cost-benefit analysis in the European Banking Association, which Heinrich is the author right here. There's a lot of cost-benefit analysis being done. I think his initial conclusion is it's not so good, but at least it's being done. And then another paper about the European Space Agency. So, there are two things that are going on in these papers. One is we're trying to help our students learn to do research and get their degrees. That's the narrow purpose. But the real purpose is they're trying to help me do my work, because these are all topics that I'm interested in and are related to my research. And it's actually been very helpful for me to be in the seminar and having these students. So I'll allude to some of these papers and how they relate to my own research as we go along. But the paper that I'm working on with an economist named Paul Rothstein from the Consumer Financial Protection Bureau, which is a federal government agency created in the aftermath of the financial crisis to focus on consumer protection in financial products, particularly mortgages, credit cards, and and other kinds of credit instruments to protect them from abusive practices. So it's a new agency that was set up in an act that was passed in 2010. It began operations in 2012, so now it's about 5 or 6 years old. If you follow American politics, which I wouldn't recommend, but if you do, you would know that there's a new administration in Washington that has a different perspective on many issues. One of the issues on which it differs from the last administration is on consumer protection, and particularly whether this agency is a good idea or not such a good idea. So it's a contested agency right now. But I began working on this project 5 years ago when it was just getting started, and a legal case was decided that was quite important in the United States. It was called the Business Roundtable case. It involved the SEC, our Securities Commission, not the CFPB. But for the first time, a U.S. court basically said that regulatory agencies need to conduct some sort of cost-benefit analysis when they adopt regulations. Now, that was a novel ruling because the statutory structures for most agencies don't specifically say you need to do cost-benefit analysis before adopting regulations. But the general rules of administrative law in the United States do say that you can't be arbitrary and capricious in your actions. Your actions need to be reasoned in some sense. And what the courts essentially concluded is that it's not reasonable, or put differently, it's arbitrary and capricious if you don't consider the costs and benefits more than the SEC did in the case before the DC Circuit. So it brought cost-benefit analysis to the federal agencies that are, I will refer to them as independent agencies, like the CFPB, like the SEC, like a number of other agencies. There had traditionally been, and this is part of my paper's methodology that I just need to explain its background, there had traditionally been administrative White House oversight of what we call executive agencies. So agencies that are directly overseen by the president have been subject to an internal cost-benefit analysis, most notably the Environmental Protection Agency and some worker safety agencies that are controlled by the president have cost-benefit analysis requirements administratively, not overseen by the courts, but overseen by an office known as the Office of Management and Budget in the White House. But until this case was decided, the independent agencies had understood that those requirements did not apply to them. Now, rather interestingly, in Brazil, as I'm learning, it's the independent agencies that are subject to cost-benefit analysis, and the executive agencies aren't. Is that right? It seems to be the other way around.
No, there's a proposal.
A proposal.
Yeah.
Okay. But at any rate, in the I should stick to the United States because that's what I know more about. This case was an important case, and just a little bit of pedagogical diversion again. The first thing I did after the case was decided was to create a teaching case at Harvard Law School on the decision, asking the students to try to figure out what does this mean for the CFPB. At the time, I was working for the CFPB, and in one January in about 2013, January 2013, 500 first-year law students spent 3 days trying to answer that question as part of their first year training. And I also gave the problem to Heinrich and Bruno and the seminar to try to figure out. But it's an interesting legal problem. The courts decide something about another agency, and then if you're sitting in the CFPB, you need to figure out what does it mean for you. That's kind of what a typical lawyer's task. And the assignment was, you're an attorney in the general counsel's office of the CFPB. What do you do about this new decision? And what the students need to look at is the statutory structure of the CFPB, which is including a requirement that potential costs and benefits to consumers and companies need to be considered before adopting regulations. So this is actually kind of interesting. Cost and benefits are mentioned in the statutory structure, but it's not kind of the economist's way of talking. The economists typically want to have net positive benefits. Benefits be greater than the cost. What this language actually says is you just have to consider. But, as a lawyer, does that mean you can say, well, it seems like there are very few benefits and a lot of costs, but now we've considered that, and let's go ahead? Or does it mean you need to consider it and then do the right thing, which is not do it if the costs are greater than the benefits? Does it matter that you're the Consumer Protection Agency and you're concerned about consumers and not producers? Does that give you some obligation to consider consumer benefits more than producer costs? Well, that's an interesting legal question about what the standard should be, or maybe put differently, it's an interesting question about what courts will overturn your rulings on if you don't do it correctly, because this is reviewable in court after the agency does its work. So there was this very interesting academic debate, which I'll kind of, or in a class, we spend a lot of time thinking about, and I will just quickly gloss over it here. There was a lot of arguments amongst academics, my contemporaries, about whether the Business Roundtable case was correctly decided as a matter of law. And, differences of opinion. It was a new decision, so it was potentially criticized as being incorrectly decided. But it hasn't been overturned, so it's still good law. There was a policy question about whether or not cost-benefit analysis is a good thing to do in the field of financial regulation. Is it possible to do it? And there were a lot of academics that were focused on the financial crisis, where the costs are huge but hard to estimate. The impact of regulation is small, hard to estimate, maybe not worth the effort to do it. Other academics thought it's worth the effort. There's a lot of, I know Todd Henderson was here this morning. His colleagues at Chicago are very much into doing cost-benefit analysis. They're kind of an economically oriented crowd. One of my colleagues here at Harvard was not into it very much, and there was a debate about whether it's a good idea or not a good idea. There was also a debate, which Bruno is engaging with, about whether the courts are any good at checking whether cost-benefit analysis has been done correctly. Do they have the competencies? Is it in the realm of economists and administrative agencies that these decisions should be made? Or do the courts have some capacity to review it, as the courts review a lot of technical issues in patent cases or antitrust cases? People had slightly different views about that. And I think these debates were all interesting and important to know about it. What I was primarily interested in, though, was trying to figure out what kind of cost-benefit analysis was being done for financial products, particularly consumer products, in part to help the CFPB decide if it was doing a good enough job. So we needed what's sometimes referred to as benchmarking to see what the practice actually was. And a little bit defensively, we wanted to create a record so that if there were a court challenge, we could say, well, here's a survey of cost-benefit analysis. This is what all the agencies do. This particular regulation, whichever regulation is being challenged, is kind of in line with best practices. So we were a little bit developing a legal record, and we were a little bit trying to find out what best practices were. And I should say on this dimension, the work has become more important because the Trump administration is very keen on cost-benefit analysis. And basically, its critique of the CFPB that I alluded to earlier is that the regulations are not producing net benefits, that they're more costly than their work, and they ultimately may be hurting consumers by restricting access to certain kinds of products. So this critique is very much alive, and there's actually kind of a variety of proposals in the legislature, which are probably not going to pass right now, but might at some point in the future, that would impose more judicial review or other review of cost-benefit analysis. So that's kind of the political context. It tends to be the Republicans and those who are more focused on cost imposed on business that are concerned about cost-benefit analysis and skeptical of it. The consumer groups tend to be in favor of the regulations, but they don't know so much about cost-benefit analysis because they think about justice, they think about fairness, they don't think about economics. And so just to locate me, I'm a little bit unusual in that I'm kind of sympathetic to consumer protection, but I'm also interested in economics, and I'm in favor of cost-benefit analysis personally as a practice, but it needs to be done sensibly. Now, one of the things that's interesting about cost-benefit analysis, for those of you who haven't gotten into it in your prior experiences, is there are a lot of different flavors of cost-benefit analysis. And they can be qualitative. And, I think most of us live our life under qualitative cost-benefit analysis. Should I go into Harvard Square for lunch? Well, there are more restaurants there, and the food is better, but I have to walk for 10 more minutes. Well, sometimes it's worth it, sometimes it's not. That's qualitative cost-benefit analysis. When you pick your spouse, probably qualitative cost-benefit analysis. All sorts of things. You can be more quantitative, have some numbers. How many minutes does it take to walk to the square versus how many, how good is the food? So a little quantity, a little quality. You can monetize your cost-benefit analysis a bit. Okay, my time is worth $50 an hour. It takes 10 minutes to walk. I could divide 50 by 6 and come up with a number. That would be the cost of going. I don't know how to think about monetizing a better meal, but if I thought about it enough, maybe I could figure that out. Or I could totally monetize all of the costs and all of the benefits. Now, the gold standard of cost-benefit analysis, if you read the Borman book, The Economist, is to be fully monetized. But there is a range of what can be done and what needs to be done. And there's a range about how you think about it. Should you do it discretionary, just sort of think about it when you want to? For cost, think about costs and benefits. Should you do a break-even analysis about how much benefits would you have to make the cost worthwhile? Net benefits, net monetized benefits. Again, you can sort of think about these things in different ways and give them different weights. And it's sort of interesting if you go around the world people do this differently. In some developed countries, like Germany, they just think about costs. Benefits are too hard to think about. They just do costs. Not unreasonable, not what we do in the United States. What we try to do in the United States, at least for executive agencies, is to have as monetized as possible and explain about why you don't have monetized benefits, because you don't have the information, you can't do the estimates, there may be reasons, but the presumption is you try to get down here and have a net monetized benefit, but you're allowed to be in other places if you explain. Now, one other interesting dimension, and the CFPB has to consider costs and benefits under the statute. It tries to monetize when it can. It so far has not fully monetized, but it's kind of in that sort of space. One other dimension is who gets to think about whether cost-benefit analysis is done correctly. And there are a lot of different choices. One choice is that the administrative agencies just decide what they think is beneficial. That's what their task is. If they're a transportation agency or an aviation agency, they just kind of make that decision. That's one possibility. You could have a centralized administrative review. That's what the White House does for executive agencies. You could have outside experts, academic panels of some sort. You could have courts deciding whether it's done correctly. That's where the Business Roundtable is, and that's where Judge Bodar's paper is. He thinks that the courts actually do have a role. That's what's kind of been debated. But there's a lot of dimensions of cost-benefit analysis. What you're considering it, how you're considering it, what degree of review is possible. Okay, so that's by way of a rather lengthy introduction to kind of what the issues are. As I said, the task that I was engaged in was trying to figure out how cost-benefit analysis was actually being done in the United States. And to some people, a rather small group of people, this is a very interesting question, but it's technical and it's detailed, and I'm just going to go through it rather quickly to give you a flavor of what the project was. The first thing we had to try to figure out was how are we going to organize our analysis? And here we borrowed from some work that I've done with some other folks here at Harvard about consumer financial protection and what are the economic justifications for consumer protection. What are the justifications for the government intervening into the markets? And this is an economic perspective, and it's one that's actually shared by a number of authorities around the world, that you have to have as a predicate a market failure of some sort. You have to have some explanation about why the market is not doing things correctly, because in a perfectly functioning market, resources will be allocated efficiently, and there won't be any opportunities to change ordering without making someone worse off and generating a net cost. So the premise of this prior work and our premise in putting together the paper was that these market failures were going to be what the regulatory agencies were thinking about and what the benefits that they were generating were focused on. And we call them the Campbell factors. John Campbell's at Harvard Economics Department. He was the lead author on the paper. One of the things that was kind of interesting is when we began actually reading regulations. And what we did is we identified 72 regulations that had been adopted in a period of time between roughly 2012 to 2014 or so. I unleashed about a dozen or 2 dozen Harvard Law School students to read over all the regulations. And so every regulation 2 students read, they coded it for trying to figure out which of these benefits and costs were evidenced. And one of the things that they found out was that there were some additional benefits that regulatory agencies were talking about with some regularity that we didn't have in our list to begin with. So we kind of expanded the list of benefits. And we put together a survey that was premised on the assumption that the asserted benefits would track this structure. Now, I won't go into any detail here about exactly which agencies we looked at, because that's kind of technical, but we were trying to find agencies in addition to the CFPB that were doing consumer protection work of some sort. So it was kind of all regulations facing consumers. Some of them were financial in nature, but a lot of them weren't financial. They were warning signs on refrigerators and gas mileage rules and various health regulations. But we wanted to sort of look across context under the assumption that it would be informative to proceed in that way. We had these students fill out rather elaborate forms about which benefits were present in each regulation, and then what degree of intensity of analysis occurred, how much monetization occurred, and how many words were used. A lot of different ways of kind of understanding what the regulations were doing in the cost-benefit analysis area. I should say that Heinrich, my student here, who wrote about Europe, we did 72 regulations with 24 research assistants. He did 85 European regulations with no help. So he was more productive by several orders of magnitude than we were in writing his paper, so good for him. But at any rate, we came up with a lot of information about these regulatory agencies and what kind of benefits and intensity there existed. And just to give you a kind of a flavor of the sorts of things that we found out. We found out what the types of market failures were thought to be: information failures, so people didn't have enough information. Cognitive biases was kind of a common justification. A lot of times the regulations, this we didn't kind of expect, were designed to clarify things and reduce uncertainty, improve compliance for businesses. They weren't so much about protecting consumers, but making it easier to comply. The other thing that we found out that was sort of interesting to us is that on average, there were a lot of asserted benefits for each regulation. It wasn't just that a regulation provided one benefit. There were multiple benefits that were being asserted. And this is kind of played a little bit into the academic literature about cost-benefit analysis, where some of the academics speculated that if you have judicial review of cost-benefit analysis, the agencies will just kind of make up a lot of benefits in order to kind of pad the record, and that really there's only one or two in each case, and in some ways we're just getting a bloated record for protection. That may or may not be true. But let me just sort of go on to say a few more things about the findings, which are that there were recurring patterns. You could sort of look at different agencies and see, different practices. But one of the interesting things is we looked at the how much quantification was going on, and these are two different measures of quality. And the interesting thing here is the agencies that were being reviewed by the White House that had sort of 20 years of experience, generally speaking, did more quantification than the CFPB or the other independent agencies. So from the CFPB's perspective, well, good, they did better than the other independents. But in some sense, they didn't do as well as the executive agencies, which is if you're thinking in terms of legislative design, maybe this is reflecting the benefit of having an external review, of having somebody that is seriously outside the agency making sure that the analysis is done correctly. So that's some of the kinds of takeaways that we were interested in. There's lots of other technical aspects of the study that I think we don't have time in this context, but I want to just jump ahead to, well, actually, this one is kind of interesting. This is another chart that shows the incidence of benefits. And under each benefit, we're now kind of dividing out by White House agencies versus the CFPB in yellow, and then other agencies in gray. And there's a lot of commonality. Information asymmetries are big in most places. Negative externalities are big in most places. But one of the things that's kind of interesting is these two charts have to do with unfairness and cognitive biases and financial capabilities. And what you kind of see is the CFPB is particularly attuned to fairness and also to what we call behavioral economic considerations. The fact that people might have limited mental capabilities, be susceptible to error. And that's actually one of the things that the framers of the CFPB were motivated by, behavioral economics. And the other independent independent agencies kind of just didn't think about cognitive biases as much. So it's kind of an interesting example of how the culture of the agency can make the benefits they're focused on more central. The final thing that I just want to mention is we were kind of, I said before, interested in best practices. What were the best practices? And so I'm so far have been focused mostly on what were the average scores and stuff across agencies. But we went through and we tried to find in each area what we thought were the best examples of analysis of information asymmetries or analysis of cognitive biases or market failures or all the different categories. And we kind of pulled out what we called exemplars, which tended to have higher scores on quantification and higher scores on monetization and more detailed analysis. That's how you got to be an exemplar. And there's a whole section of the paper that looks at how good are the best things. What did the best ones do? And this has been sort of hard for my co-author who does this professionally, because the answer is they're not that good. They're definitely not what is being taught in the schools of public policy as the right way to do things. They're relatively limited monetization. Sometimes when you drill down, the agencies say, well, we assume that half the people will benefit, and we assume that it will be worth so many dollars, and therefore the net benefit is, the product of those two things. Well, there are two assumptions. Are the assumptions good? Are they not good? It's monetized, but it's not that well substantiated. It turns out that it's rather hard to do this work. It takes a lot of time and effort to develop it, and the agencies here are really just beginning to do consumer protection analysis. And one of the interesting questions for us is the question of, well, could they have done better? We can look at what they did. It's more work to figure out, well, with any different regulation, if they tried harder, was there more information that they might have used? And that's, again, where the students at Harvard Law School come in. The students who are writing papers for me this semester are looking at a specific regulation, analyzing how well they did, but also trying to figure out, might they have done better? Was there research that they missed? Was there other sources that they might have relied on? Was there stuff that just is not available that they needed? And that's another task for academics, maybe more economists than lawyers, trying to develop better parameters. So in the environmental area in the United States and in the health area, a lot of work has gone into figuring out a statistical value of life, so that if a regulation saves a life, there's a number that you can put in to sort of say, well, this is the approximate value. And with carbon emissions, there's been a lot of effort about the social cost of carbon, which at least the Obama administration used in its regulations to decide whether the costs were worthwhile. In consumer protection, that work really hasn't been done. How valuable is it to avoid financial distress? We don't have a standard estimate for that. How valuable is it to avoid foreclosure in the mortgage markets? We don't have a readily usable and agreed upon value for that. So one of the next stages of the project is to encourage our economist friends to work on those parameters as well. But one of the values of going through all the regulations is to see the areas where information of this sort might be useful, and then to try to figure out whether it's available currently or might be made available. And again, the students' research for the seminar and other projects is feeding into that. So that I went a little bit over the time you suggested, but maybe can we have some time for maybe questions if there are any?
Yes, first, thank you, Professor, for the wonderful talk. There's a question here, I think it was Heinrich, that asked whether I'll get honors in your seminar.
Well, it's too soon to tell. We need more parameters, like the final paper. You didn't. Well, nevertheless, it's the answer.
So there are some questions here because you mentioned like unfair outcomes, and they wonder how can we actually determine what is an unfair outcome in practice. In Brazil, we're discussing a huge reform of the pension system, and then they are asking how can we take these fundamental and moral considerations into account in CBA, and the same for consumer rights and the dignity of consumers.
Yeah. So this is, one of the complexities of cost-benefit analysis is which benefits do you consider. And so if you look down this list, the top of this list is all kind of neoclassical economics. All traditional economists would kind of agree with those things. And maybe the younger economists who were trained in behavioral economics, it's still a little bit controversial in certain circles, but would kind of add in cognitive biases. People with pensions, for example, do a very bad job weighing spending money today and having money in retirement. They kind of discount the future a lot, and then they get to retirement and they're unhappy. So that's a kind of well-known cognitive bias. Every store manager knows that if you don't focus on the price, but you say it'll just cost you pennies a day to buy this product, people are more likely to buy it for pennies a day as opposed to $100 a day. So that's kind of a well-known cognitive bias that most people would recognize. This unfair outcomes, as Bruno says, so what is this? And we kind of, when I was doing these papers with the economists, we sort of had fights about unfair outcomes. And what I would say is, our view was, in a context of a list that is mostly grounded in standard economics, it's okay and maybe even appropriate to have unfair outcomes to pick up certain kinds of behaviors that most people, when they look at it, would say an interest rate of 4,000% a year is just inappropriate, unfair. There's something wrong about usury at some level. Now, I would be concerned if you looked at a regulatory system where everything was primarily based on unfairness as a justification, that there wasn't usually a more kind of standard justification. But I'd also worry a little bit about a legal system, and these are political institutions reflecting political judgments, and sometimes the mandate, for instance, of a consumer protection agency is to protect consumers from certain kinds of unfairness. So I think it's contested. It's justified in a distinctive kind of way, a little bit as a mental shorthand that there are certain kinds of things that are inequitable. Probably if you were super disciplined, you could locate them in one of the other justifications, but it's a little bit of a catch-all that we do include. And as you can see, the agencies do talk about it as unfairness is something that they take into consideration.
And there's also a question by Benedito. How does CBA relates to risk analysis?
It relates to it in that oftentimes CBA will reflect a range of estimates of a cost, for example, or potentially a benefit, but reducing a risk that will have a distribution. And we tend in cost-benefit analysis to take the central estimate, the expected value, but sometimes we do sensitivity analysis that looks for the distribution, and there are kind of approaches like the precautionary principle that kind of is particularly sensitive to extreme bad outcomes, which is more kind of risk analysis. But in the majority of the consumer protection stuff that I'm looking at here, you don't have the big tails that you might have around, say, nuclear plants or certain environmental issues, that you have big downside possibilities that you'd want to be particularly attentive to. And you could use kind of a risk aversion adjustment. There are technical ways of bringing it in to your estimates. But usually in this range, the central expected value is what we tend to use as our estimates.
Okay, so we ran out of time. Professor, again, thank you very much for your lecture today. It was wonderful. We learned a lot. And we have a certificate